The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. I'd like to welcome all of you who are on the Zoom call, as well as those who are watching via our Supreme Court live channel. I'd also like to take a moment this morning to welcome and introduce Judge LaDonna Lanning, who is sitting with us in the position vacated by the recent retirement of Justice Carol Weyer. Judge Lanning is a district court judge who sits in Field County, Kansas. And she has served in that position since January of 2011. Judge Lanning has taken time from her busy docket to help us, and so we want to express our appreciation to her publicly. Judge Lanning, we're very honored to have you sitting with us today.
Thank you, Justice Lukert. I'm very honored and feel privileged to be able to experience this with all of you. I do wish it was in person. I think it would be far more interesting, but the times are what they are. So thank you for thinking of me. I appreciate the honor, Chief.
We agree. I think we all look forward to the day we're back into the courtroom. I think counsel would agree as well. So, but as you said, this is working well for us during this pandemic time when we still can't socially distance because of the limitations of our bench and otherwise. With counsel, I would just remind you that not only Judge Lanning, but the entire court has read your briefs, and we are definitely looking forward to your arguments this morning. So with that, I'll ask Mr. Doug Shima to please call the 9 o'clock docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Friday, October 30th, 2020 consists of one case. Appeal number 120726, State of Kansas versus Keyshawn Milo, Sedgwick County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Counsel, would you please state your appearances?
May it please the court, Kai Mann of the Appellate Defender's Office on behalf of the appellant, Keyshawn Milo, ready for argument.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Thank you, counsel. Mr. Mann, you may proceed with your argument.
Thank you, Your Honor. May it please the court. On December 2nd, 2016, Keyshawn Milo was contacted by Ryan Wellborn about selling 4 ounces of Gorilla Glue to MH. This was despite the fact that Mr. Milo is Black and MH held racial animus towards Black individuals and would regularly use racial slurs, including the N-word. MH was also using methamphetamine and cocaine at the time, which his family testified made him angry and crazy. Mr. Milo eventually picked up Mr. Wellborn. From there, Mr. Wellborn gave 2 versions of the events that occurred. In his first interview with police, Mr. Wellborn testified that they had made several stops before arriving at MH's home and that Mr. Milo had sold all of the Gorilla Glue during the previous stops, leaving none left to sell MH and sending him into a fit of rage. In the second version of events, Mr. Milo arrived at MH's home with Gorilla Glue, but a dispute broke out over method of payment. In both versions, MH pistol whipped Mr. Milo, repeatedly striking him in the head with a loaded gun and fists, while hurling racial slurs, calling him the N-word, and causing Mr. Wellborn to fear for both Mr. Milo and himself. While Mr. Milo regularly carried a firearm for self-defense and carried one into MH's house, Mr. Wellborn did not see Mr. Milo brandish his gun. Eventually, as MH was forcing Mr. Milo to the door with his gun and the two were face to face, Mr. Wellborn heard a gunshot, followed by Mr. Milo pushing MH back into the home. MH fell back into the home, but kept his gun trained on Mr. Milo. Mr. Wellborn testified that he heard additional gunshots as he fled to a QT nearby. MH would die of a gunshot wound to the chest. Mr. Milo was eventually charged with 1 count of felony murder with distribution of marijuana as the inherently dangerous felony. At the preliminary hearing, Mr. Wellborn testified as to the second version of events of distribution of marijuana, a forcible felony. To the second version of the events, and the district court denied Mr. Milo self-defense immunity, finding that he was barred from exercising such during the commission of distribution of marijuana, which it found to be a forcible felony. At trial, the district court refused to instruct the jury on self-defense for the same reason, and also found that even if he had arrived empty-handed, that there was still an attempted distribution of marijuana. The district court overruled his objection to instructing the jury on attempted distribution and also denied his request that the jury be instructed that if he did not arrive with marijuana, there could be no attempt. The jury convicted Mr. Milo, but did inquire as to self-defense despite no instruction being given. The district court sentenced Mr. Milo to a hard 25 sentence, and this is his direct appeal. The first three issues of this case really revolve around two questions. The first question is whether or not distribution of marijuana or its predicate attempt is a forcible felony. The second question that must be answered revolves around whether or not a person arrives empty-handed, whether or not they can distribute something they don't have, which in this case would be marijuana. In this case, the district court erred in both of these determinations, but I would like to start with the marijuana as a forcible felony. Now, pursuant to KSA 5226A, self-defense is unavailable to one who is attempting to committing, or escaping from the commission of a forcible felony. Forcible felony is a defined term that is defined as any treason, murder, voluntary manslaughter, rape, robbery, arson, kidnapping, aggravated battery, aggravated sodomy, and any other felony which involves the use of threat of physical force or violence against any person. This is a case that clearly involves this residual clause. Now, the first argument I'm going to make regarding this residual clause is that that residual clause, as interpreted by this court and applied to Mr. Milo, is unconstitutionally vague, as it fails both the tests for constitutional vagueness. First, it fails to give adequate warning to those subject to it, because this is, and secondly, it doesn't guard against arbitrary and unreasonable enforcement. Really where this comes down to is the word involves and what this means. This court has previously interpreted that phrase to allow the court to look to the surrounding circumstances of the underlying felony to determine whether or not it is a forcible felony or not. However, this is error, as the word involves, as I noted in my brief, should really be interpreted more to be required to where we look at the strict elements of the underlying felony to determine whether or not it truly does involve threats of violence. The reason for this is pretty simple, and there's a few of them. First, distribution of marijuana is nothing like the other felonies that are listed and enumerated in the statute. Applying the canon of nocitur associes, there's no way to determine that distribution of marijuana fits within rape, robbery, murder. Those are all felonies that involve violence, that involve threats as in order to actually commit that crime. Whereas, as this court has previously held in Wesson, distribution of controlled substances do not inherently involve violence, but any violence that breaks out is simply coincidental with the situation. In fact, I would argue that distribution of marijuana is inherently a cooperative endeavor, and generally it goes off without a hitch. And we see this time and time again with the amount of CIs that are used in drug cases throughout the state by the police. And if distribution of controlled substances were truly that dangerous, it's just absolutely reckless to use citizens to make these types of stings. Furthermore, it must be noted that self-defense also covers self-defense of others under 2152.22. So when we look at these enumerated felonies, these are all felonies in which a person who viewing another trying to rob or rape or murder somebody would likely intervene, and therefore that subsection cuts off the attacker from being able to defend himself from the lawful self-defense from a third. If somebody sees an attempted distribution of marijuana going down, that is not going to provoke the same type of reaction. And therefore, there's just really no way to read this section to include distribution of marijuana. Furthermore, under the current interpretation of this section, it effectively removes the forcible nature of the felony, because any felony under this definition can be a forcible felony. And furthermore, any time self-defense is exercised, we're already in this violent scenario. So examining the circumstances surrounding the commission of an otherwise non-forcible felony, if self-defense is used and self-defense is lawful because you're repelling the acts of a third person, it's always going to be a forcible felony. That's because the violence is there.
Counsel,
Yes.
Do you think, why isn't just showing up at a drug transaction with a firearm the threat of physical force?
I think that I think that's overlooking the amount of places people carry firearms these days. It's not uncommon for people to carry firearms to Walmart.
But Walmart is not illegal. Going to Walmart is not illegal, but selling drugs is. So doesn't the nexus between conducting a drug transaction and bringing a firearm to that transaction, doesn't that at least implicitly indicate a threat of force?
No, I really do not think so. Again, many things are not illegal, but people carry guns all the time. And again, we also have a constitutional right to carry a gun. In fact, the trial, the information was elicited that Mr. Milo primarily carried a gun following the murder of his mother. You know, there are many reasons for people to carry firearms. And just because a person is exercising one constitutional right while breaking some other statute shouldn't necessarily make the situation inherently dangerous. Because again, if the presence of firearms makes situations inherently dangerous, life in this state is inherently dangerous given the amount of guns and the laxity with which our open carry laws operate. So therefore, I think this court gets a skewed perspective of this because felony murder is a first degree. And since we've had these, we only see the cases where these drug deals go wrong. Again, the carrying of the gun and the selling of the marijuana are not necessarily related because Mr. Milo regularly carries for self-protection. He just actually has to use it.
Mr. Mann, can you distinguish this and our Belts case in 2017, which has a similar circumstance? It's, for lack of a better phrase, a botched drug deal, and the participants were carrying a gun, and we held that was a forcible felony, at least for felony murders, the underlying felony murder. How is this case distinguished from that?
Well, the problem with Belts is that it all goes back to Mitchell. And I went through the history of our, forcible felony and our first degree murder schemes and how they used to be reinforcing one another, because we used to look at the definition of forcible felony to determine which felonies are inherently dangerous. Back when the first degree murder scheme allowed for any felony. Now, since our modern version of the felony murder doctrine, where the felonies are statutorily enumerated, it makes no sense in Mitchell, they said, oh, they enumerated felonies, therefore these felonies must also be forcible. What actually should have happened is that once there were a statutory list of enumerated felonies, there's no reason to try to fit all the inherently dangerous felonies into all the forcible felonies because they control two different things. Since the legislature put all the inherently felonies as statutorily defined, it simply presents a situation where we have versions of felony murder in which self-defense is a valid defense because not all of the inherently dangerous felonies are forcible felonies. So that's where Belts is wrong because Mitchell is wrong. And everything that has gone on since Mitchell is when it overruled Wesson and all those cases there. So really it's Belts is wrong because Mitchell is wrong, and Mitchell and its progeny need to be overruled because they're based on flawed statutory analysis.
Just go ahead.
Sorry, Chief.
Go ahead. Justice.
Speaking of the statutory analysis, you started your argument by claiming that the last part of, I think it's 5111, is a residual clause. But do we really have a residual clause here? Because residual clauses typically talk about, they end a list and they end it with something like, or any other, in this case it would be, or any other similar felony. But that's not what this is. This is actually a definition, that involves the use of threat or physical force or violence. I guess I'm confused by your argument that that's a residual clause.
It may be a residual clause. And again, maybe this is exposing my own misunderstanding, but I always view residual clauses as a kind of catch-alls. So we have these immunities, plus everything else is kind of similar. And in this case, the clause states any other felony which involves the use of threat of physical force or violence against any person. Now, all the enumerated felonies do involve the use of force or threat. No,
Well, does treason involve? I guess I'm questioning or probing the similar element, because you again used the word similar, but there's no use of the word similar in the statute.
no, but the use of any other, I think, it goes to show that those felonies must be similar to the enumerated felonies, and therefore we're not looking at the surrounding circumstances, because again, then we would just have no forcible felony rule. It would just be the commission of a felony, because again, once self-defense is authorized and used, we have a situation involving violence by the plain terms. And again, I would like to note that I was able to identify at least 10 other felonies I think would fit under this residual clause using a strict elements approach. So this isn't restricting this down and getting everything out. It's just that under the list we have now, to me, including distribution of marijuana, it would read as watermelon, honeydew, cantaloupe, race car. One of these things certainly doesn't fit. And the distribution of marijuana is a race car because it's nothing like rape, robbery, sodomy, or any of those other felonies.
You make the point that forcible felony does not necessarily equate to inherently dangerous felony. What do you see as the distinction? What separates the two categories?
It's kind of like bungee jumping. Bungee jumping is inherently dangerous. The harness might fail, I might hit the ground, but I'm not forcing anybody else to do anything. I'm not coercing. I'm not using violence against anybody else but myself. So things that are inherently dangerous aren't necessarily forcible because there is no threat of violence. There is no actual harm that must be done for the felony to be completed. Any violence that occurs within a distribution of marijuana is simply coincidental. Because again, we can't forget that this is distribution. It's transferring from one person to another. The vast majority of drug cases that come across my desk are cooperative endeavors. There are people who've bartered on a price, they've agreed to it, and one person distributes to another. It's just like buying anything else, except for it happens to be an illegal product. But that doesn't make the actual buying or selling dangerous. It's just the violence that is involved is just coincidental and frankly not even that often, because again, I get far more drug cases where it's a person who sold to somebody wearing a wire who's not even a police officer, as opposed to these crazy shoot 'em up events. I see that I have run out of time. I have no more prepared remarks, but more than happy to answer any questions.
Counsel, since Mitchell, what role does the abstract elements of the crime itself play? It seems to me that it almost becomes an afterthought in our case law subsequent to Mitchell, but does it have a role? And if so, how do we balance that with the fact-specific inquiry, assuming that's a proper interpretation of the approach under the statute?
To me, the way I read the case law is that Mitchell expressly substituted a inquiry of the circumstances for the abstract approach and the strict elements. I think that the only fair and true way to actually give notice and to give meaning to this definition, which again, 5226 is the only statutory provision to use that phrase forcible felony. So it has to mean something. So I think that the only way to give that phrase dignity and to give it meaning, as well as to fulfill the legislature, is to restrict that analysis to the elements of the crime that is alleged to be forcible.
Are there other questions? Thank you, Mr. Mann.
Thank you, Your Honor.
Mr. Maloney, you may present your argument.
Thank you, Chief Justice. May it please the court, Assistant District Attorney Matt Maloney for the state. Obviously, I'll focus my remarks on this first issue, the vagueness challenge. And I want to start, before getting to the merits, I want to start to the primary argument that I asserted in our brief, which is that our position is that this argument is not properly before the court based on the fact that while the defendant did make a last-minute attempt to raise the vagueness argument at the instructions conference, this court's case law clearly indicates that in the context of an immunity type proceeding, it's essential that the arguments be raised as early in the proceedings as possible. And in my experience in dealing with these cases, that's one of the things that the defendant is typically emphasizing, is that the reason the immunity statute is so important is that it prevents a defendant from ever having to go through the criminal process if it is invoked and if the court rules in the defendant's favor. So here we have a situation where the defendant did not even raise initially the issue of immunity in general. The court, sua sponte, addressed that at the conclusion of the preliminary hearing. And then in the weeks that followed, the defendant began filing some motions where he was arguing that he was entitled to immunity, but he never raised the vagueness challenge, even in those written pleadings. And it wasn't until the instructions conference that he first brought this issue before the district court. I cited in my brief this court's opinion in Astorga. And I acknowledge up front that there is a distinction in that Astorga never raised the issue before the district court. And in that situation, this court held that it was not properly raised and that there was no need to address it out of fundamental fairness concerns because the defendant had separately challenged the manner in which self-defense was instructed upon. Here, the defendant likewise has also separately challenged the self-defense instruction or the lack thereof. So our position is that while unlike Astorga, the defendant did attempt this last minute argument about the vagueness aspect of the statute, that's not enough. When the defendant has already gone through not only a preliminary hearing, but an entire trial, the case is basically in the jury's hands by that point. We don't think that that's timely, given this court's emphasis that these issues need to be raised as early as possible in the proceedings. So that is our primary position, is that this issue should not be addressed, and that simply addressing the self-defense argument in issue 2 is sufficient to eliminate any concerns about fundamental fairness. Obviously, I am prepared to address the merits, and our position would be that if this court elects to do so, that the defendant is not entitled to relief. I think.
Counsel, can I probe a little bit on that?
Sure.
My understanding is that the lower court did deny the immunity motion on the grounds that this was a forcible felony. Is that right?
Yes, I believe so. Yeah.
And so, setting aside vagueness, I guess, the defendant did clearly raise the forcible felony question. So why isn't that properly before us, even if it's just as a matter of statutory interpretation?
And that's certainly a fair point. And that, as I prepared for this argument, that was one of the things that struck me, is that issue 1, while the defendant characterizes it primarily as a vagueness challenge, as I read through the brief, I think there definitely is a distinction between a vagueness challenge and simply a typical statutory interpretation argument. And our position, and I think that's fair, I think that this court would be in position to simply address the statutory interpretation argument, but not the vagueness challenge. And as I read the defense brief and listen to the arguments, what strikes me is that the defendant essentially just disagrees with the manner in which this court has interpreted the use of the word involves. And in my interpretation and understanding of the case law, that's not really a vagueness challenge. The vagueness test tells us that if a statute uses ordinary words and or is a statute that this court has consistently interpreted and there is a well-known judicial meaning, the defendant cannot prevail on a vagueness challenge. And certainly in this situation, I don't think that anybody could reasonably argue that the word involve is not a commonly used word, whether you're talking about a legal or non-legal setting. And then turning to the judicial interpretation and well-settled meaning, we have now almost a quarter century of case law since Mitchell in which this statute has been determined to include drug sales such as the one involved in this case.
Yeah,
so the defendant might...
I think, and obviously we heard your opposing counsel ask us to overrule Mitchell and all of its progeny. In looking at the defendant's brief, I think the defendant pretty clearly makes a plain language argument there. So I would like to hear the state's position vis-a-vis the plain language of the statute. Does the plain language encompass sale of marijuana?
Yes, our position is that it does. In the plain language argument, the defendant relies quite heavily on the Florida Supreme Court's interpretation of a similar statute. And our position is that the Florida Supreme Court got it wrong. I don't think that there's anything in either the Florida statute or the Kansas statute that indicates that the use of the word involves is intended to limit it to a strict elements definition. I think that when you read that statute and look at it as a whole, it does support the Mitchell Court's ruling that that analysis includes not only a strict elements analysis, but also a consideration of the underlying circumstances of any given felony in a certain case. And I think that's well reasoned. I think that, first of all, the very use of that phrase at the end of the statute, whether we want to call it a residual phrase or not, or a residual clause, I think that the very use of that language indicates that the legislature intended for the courts to be able to include an analysis of the circumstances. Because if not, the legislature would have been very easily able to do one of two things. They either could have just specifically said that it was limited to an elements analysis, or they simply could have said and listed out all of the specific crimes that they intended it to apply to. But instead, by including this catch-all provision at the end of the statute, I think that's as strong an indication as possible that they realized that there were going to be other crimes where, given the circumstances of a certain case, that force or the threat thereof was involved. And so they gave the district courts and appellate courts the ability to look at the facts and the circumstances by including that provision at the end. So I think that just the very use of that phrasing indicates that that is in fact what the legislature intended. And I think that that very much does support the Mitchell Court and subsequent courts' interpretation of the statute. Involves, the definition that the defendant cites for involves, indicating that the crime as a necessary requirement includes threat. Even if you accept that definition, I don't think it supports a conclusion that that means that the crime involves or includes force simply based on a look at only the elements. I think it does allow for a consideration of the circumstances. And one aspect of counsel's argument that I strongly disagree with is him arguing that this is really no different than the sale of any other item. And he points out that many drug transactions go down without any violence occurring. And while certainly I'm not going to dispute that there are plenty of drug transactions that don't end up going sideways and where both buyer and seller agree on a sale and both walk away happy with the exchange, the fact that many sales come off without a hitch doesn't mean that this is in any way similar to the buying or selling of any object. And I think, I can't remember which of your honors pointed this out, but I think that just the very fact that it is by no means uncommon for people engaged in these transactions to arm themselves does clearly indicate that the participants themselves recognize that this is something beyond just a normal transaction. I don't think that normal people go to a car dealership and think to themselves, I better arm myself here just in case something happens. And this case is a perfect example of that. Counsel can point out that, well, people oftentimes arm themselves in all sorts of scenarios. And I think Justice Stiegel, your point is a very, very good one, that the difference is there is nothing illegal about going to Walmart or driving down the road. And this statute, the forcible felony requirement, requires both the not only the danger or the risk or threat of force or physical violence, but it also requires that the person be involved in a felony. And so, again, I don't deny that there are transactions that occur that don't ultimately end up resulting in any violence. But my caseload suggests that this is very much an activity that increases the risk of violence or the threat of force significantly. And there's a reason why so many buyers and sellers go to these transactions and are armed with weapons. In this case, we have both buyer and seller that had a weapon available to them. And I don't think it's a coincidence. And I don't think it's something where you can simply say, oh, they were simply exercising their constitutional right to have a gun with them, and there's nothing inappropriate about that, and that it's completely divorced from the fact that they were engaging in a risky behavior.
As I understand your argument, you were really saying that we wouldn't necessarily categorically put all sales in a forcible felony category, but we would look at the facts of the case to do that. Seems that perhaps even under your argument, then we have some language in some cases that goes further than you think the statute would direct us. Am I accurately understanding your argument?
I think that the case law does indicate that, yeah, you do have to look at the circumstances of each individual case. So to the extent, yeah, I think I would be comfortable acknowledging that there could be certain transactions where a court could look at it and reasonably conclude that, based on the specific circumstances, that particular drug transaction would not constitute a forcible felony. So perhaps if you have a situation where two people that are not only acquaintances, but good friends who have a history of buying and selling drugs or even using drugs together, if two friends both come to an agreement that one's going to sell the other a small amount of marijuana, and if neither person is armed with a gun or any type of weapon, I think that it would certainly be reasonable for a court to look at those particular facts. And in that type of a case, it would very much be a close call as to whether in that type of scenario, it would meet the forcible felony definition. So I do think that there is certainly some leeway there for the court to look at that. And I think that if there were no leeway, then I think then the legislature would simply include the sale of marijuana as per se, like they include burglary or battery or rape or some of that crimes that are specifically enumerated. So yes, to answer your question, I think that there could be scenarios where a certain drug transaction might not meet the definition of a forcible felony.
Mr. Mahoney, do the facts and circumstances then extend to any felony? I'm going to commit a forgery. I'm going to write something in a transaction that doesn't accurately purport myself or something like that. It's a forgery. I happen to bring a gun and it goes awry. Do the facts and circumstances in that instance support a forcible felony? I mean, how far does this go to when you're in the commission of any felony?
That's certainly an interesting hypothetical, and I think when you look, just reading again the exact language of the statute, that any other felony which involves the use or threat of physical force. So I guess maybe in that particular example, the court would have to look at it and say, okay, did the defendant in that scenario bring the gun with him because he or she specifically envisioned that there was the likelihood that something could go awry with that and was bringing the weapon for those purposes, or just happened to incidentally have the gun with him? I think that is the type of scenario where, yeah, you would have to look very closely at the facts. And I could certainly see that would be the type of situation where a court could say that that particular felony was not. But I don't think there would be any specific crime where you would categorically say that it could never be considered a forcible felony. So I think to answer your question, again, it would always come back to a look at the specific circumstances of any given offense. And I think to kind of tie back into the vagueness challenge, to the extent that the court were determined that that issue was properly raised, the case law tells us that just because there are outlier cases where it might be a stretch to apply it, or it might be difficult to determine whether it applies, that's not enough for a defendant to be able to succeed on a vagueness challenge. And so there again, I think that that type of hypothetical might illustrate that while certainly this court can look at the statutory argument that the defendant is raising, it would not be something that would allow him to succeed on a vagueness challenge.
Counsel, do you agree with your opposing counsel's argument that if we look at the facts of the case, the actual self-defense or the act that's claimed to be self-defense cannot satisfy the use of physical force or violence element? In other words, the court or the fact finder would have to conclude that the felony involved the use of physical force or violence, but can't look to the actual self-defense.
I certainly logically understand his point, because if, as he's arguing, if you could simply look to that, then it would be difficult to envision a scenario where a defendant could ever succeed, because by definition, the only reason that the case has reached that point is because force did ultimately get used. So I don't know that I necessarily would be willing to go as far as saying that you can never look at that, but I do think that in this case, I don't know that the court needs to reach that issue or that particular question, because here we do have the scenario where even before the ultimate use of firing the gun, the fact that the defendant did arm himself and bring this gun to the transaction, and the fact that the would-be buyer also was armed. I think that even long before the actual gunshots were fired, in this case, we have the use or threat of force or violence. So I don't know that the court needs to ultimately answer that question in this case, but I certainly can at least acknowledge that counsel does have an argument that has some logical appeal to it. I see that I'm past my time, and certainly would be happy to answer any additional questions, but to summarize our position, one, we do maintain that this vagueness argument is not properly before the court. And secondly, we would assert that the statutory argument that the case law that this court has followed now for almost 25 years is well reasoned. And we would ask this court to continue to look at not only the strict elements of an offense, but the circumstances surrounding any particular crime in determining whether a forcible felony is involved.
Any other questions? Thank you, Mr. Maloney.
Thank you.
Mr. Mann, you reserve 3 minutes for rebuttal. Mr. Mann, you are still muted.
Apologies. Am I? All right,
I can hear you now, yes.
May it please the court. First, I would like to start off with counsel's attack on the preservation of the vagueness challenge as to the immunity. As we discussed a little bit yesterday, this exceeds any preservation challenges because self-defense is a constitutional right protected by Section 1 of the Kansas Constitution. Section 1 protects the right to bodily autonomy and the right to bodily integrity. Self-defense is the purest expression of those concepts. It is even almost more than a right. It's the instinct to self-preservation. And for the simple fact, and so therefore this court should reach all of those constitutional arguments as they relate to the instructions and the immunity. If this court, chooses not to reach them as they relate to the immunity, this court must still reach them as they relate to the instructional issue and view that as a lens under the constitutional harmless error standard, which the state simply cannot meet in this case. The jury asked about self-defense after hearing all the evidence, despite not being instructed on it. And again, even if distribution of marijuana is a forcible felony, which, I'm going to still stand vigorously that it's not, because it is nothing like those enumerated felonies, there's evidence in this case that Mr. Milo didn't even have marijuana when he showed up to to MH's house. So even if distribution of marijuana is an inherently dangerous felony, the self-defense instruction still needs to be given because there was no attempted distribution of marijuana and because he did not have it when he showed up. Furthermore, there's a lot of constitutional issues in this case. It involves the right to present a defense. It resolves the right to self-defense. It involves the right to possess a firearm under Section 4 of the Kansas Constitution Bill of Rights. Now, I know I discussed constitutional avoidance in my brief as it relates to the vagueness challenge and how this court can interpret that provision to be logically sound and constitutionally sound. But I also want to point out Section 4 or Issue 4 of this brief. The state put no effort into proving that there was marijuana. They allegedly seized it, but the only evidence of marijuana is the investigator saying that, yeah, those baggies look like green, a green botanical substance. There's no pictures of the marijuana. They did not present the marijuana at trial. There was no KBI testing of the marijuana. And Mr. Wellborn said he saw the marijuana, but in reality, all he saw were 4 opaque brown bags. The only reason this case is being charged as a felony murder case is because they're so easy to prove. However, the state in this case simply did not do enough to even prove the underlying felony to support the murder. So therefore, if this court doesn't want to grapple with the constitutional questions and the vagueness questions, that is an easy escape route because the state simply fell down on their burden to even try to attempt to prove that there was any marijuana to be distributed, and Mr. Wellborn also testified as such. Therefore, I would request that this court grant Mr. Milo a new hearing so the district court can determine whether or not he was justified to use force after finding that distribution of marijuana is not a forcible felony. And if this court does find that the state can present probable cause that the use of force was not statutorily justified, a new trial at which Mr. Milo's jury will be instructed on self-defense.
Any additional questions of counsel? Thank you to both counsel for your arguments this morning. We will take this appeal under advisement. Court is now recessed until